So you've met with your attorney to discuss your estate plan. Documents are drafted, you've signed everything, including a deed to transfer your house into your trust. All done, right? Well, not exactly. Almost. There are generally three parts of your estate: real estate, finances, and personal property. Typically, when signing your estate planning documents with your attorney, you're going to be addressing the real property and personal property to make sure those are titled into your trust. However, that leaves your money still to be addressed. We've discussed transferring bank accounts into your trust. It's the best performing video on this channel, so chances are you've seen it, and if you haven't, we'll link to it in the corner. Today, however, I just wanted to stress the fact that just because you've signed your trust and that trust references an intent to hold bank accounts in trust, perhaps going as far as to list account numbers, that does not mean the bank account is automatically in trust. So let's talk about that. My name is Andrew Bethel, and as an estate planning attorney, I of course help my clients plan their estates so as to save time, avoid headache, and avoid or at least mitigate any potential fees that may impact one's estate. However, because I'm helping others to plan their estates, there are some inherent limitations to what I can do on behalf of my clients. Meaning that if you're going to be creating an estate plan, then you're going to have some homework, especially when it comes to bank accounts. What I'm getting at is simple. I can't walk into the bank and retitle bank accounts into the name of your trust for you. The bank won't talk to me because I'm not you and it's not my money. There is some wiggle room if you had a financial advisor, in that I can, and often do, coordinate account titling with my clients' financial advisors. However, that still requires the client to give permission for the advisor and I to share information, meaning there's still a small task for you to do. What I do for my clients and what your attorney should do for you is to walk you through each and every financial asset you have and develop a strategy on how best to address each asset based on your situation and staying within our goals of keeping the administration of your estate easy and as cost effective as possible. Every bank is going to have their own form, every institution is going to have their own regulations, and none of them are going to talk to your attorney out of the blue. Thus, just because you've signed your estate plan and a deed to transfer your home into your trust doesn't mean the planning is done. We need to ensure your financial assets are addressed, otherwise we might have to go to court, which was a primary reason for creating the trust in the first place. So let's talk about that next. A major source of time delay, headache, and burning cash is probate court. The primary reason for creating a trust is to avoid probate court and everything listed before that comes along with it. However, if you have a large enough amount of financial assets in your name alone, not in the trust, then we may have to go to probate court just to transfer those assets into your trust and then to the beneficiaries as initially intended. Let me give you some real examples of cases that we've come across in our office. Of course, I'll only provide numbers so as not to reveal personal information. First, we have the Red Estate, wherein husband and wife had 2 pieces of real property, an interest in a corporation, 5 bank accounts, 1 life insurance policy, and a few miscellaneous assets, outstanding compensation and loan repayments coming back to them. Overall, the total estate value was around $2.1 million to work with round numbers. While the real estate and miscellaneous assets were able to be administered directly by the trust, none of the bank accounts or the life insurance policy could be included. The bank accounts were all held jointly as husband and wife, not in the trust, and the life insurance policy on wife had husband directly listed as the beneficiary. They didn't retitle those financial assets into the trust, and when the wife passed away though, probate wasn't required. That was until husband passed away a year later though, without having done anything with the bank accounts or having collected the life insurance proceeds. Well, after husband passed away, it was on daughter to administer the trust, and lo and behold, we discover the issue with the bank accounts and uncollected life insurance proceeds, now simply titled into dad's name alone. Thus, instead of doing a straightforward trust administration, we had to do a probate alongside the trust administration because the total value of those assets in dad's name alone was over $184,500. It was approximately $258,000 that needed to be probated, meaning the family was out an additional $9,700 between attorney and court fees for the probate alone. That's an additional $10,000 out of the estate because the homework of retitling bank accounts and financial assets wasn't done during a lifetime. Our next example will be shorter because I think you get the point. We have Blue Estate, wherein a widow has a trust set up that holds her house that's worth approximately $700,000. As the successor trustee was trying to close down bank accounts, however, she began to discover that the decedent, Blue, had a good amount of cash spread across many different accounts that were never put in trust. Individually, these accounts would not trigger probate here in California, but when we began getting an idea of what was in each account, we realized that there's $50,000 over here, $40,000 over there, $75,000 over here, all of which was in Blue's name alone, not in her trust. Now we're doing a probate on approximately $450,000 in financial assets, meaning the family is going to be out approximately $13,000 in fees to administer these financial assets, when they should have ideally been in the trust years prior. I'm going to give the same advice I gave on our video warning folks to stop putting their children on title with them, which is this. Estate planning attorneys, like us, frequently rectify mistakes stemming from not properly transferring all assets into one's trust. These issues might be lucrative business for us attorneys, but they're a headache for families and are very costly. Again, watch our video on how to put assets into a trust for more information on the process of funding your trust, so your estate doesn't have to pay out more money in fees than necessary. I hope this video shed light on a critical error some people make. I'm Andrew Bethel, guiding you to make the best decisions for you and your loved ones. Drop a comment below if you have any questions. Don't forget to like and subscribe if you found this video helpful, and check out our other great videos. Stay informed, and I'll see you next time.